Item number 56.
Honorable, I appear for the Eastern Coalfields Limited, my lord.
Lord, I am for the petitioner,
Is
my
to
lord.
take up your lordship's last order dated 8th of June 2023. Matter was argued at length on that day, my lord. It's concluded more or less.
8th of June.
Yes, your lordship's only query.
1 second. Yes.
Yes, my lord. Your lordship's only query was, as he has raised that point of this persons of under the Disabilities Act, my lord, Physical Disabilities Act, my lord, whether the relaxation has any retrospective effect or it's with prospective effect, my lord. My humble submission today before your lordship would be, my lord, first of all, the 1995 Act is repealed, my lord. It's a 2016 Act which is in vogue right now. 1995 Act has gone, my lord, and this is a compassionate appointment. This is not a new recruitment. So probably that act has no application. And furthermore, my lord,
Compassionate appointment will also be like a
but
recruitment.
my point is the delay and latches, my lord. There, my lord, the relaxation of age does not come, my lord. And second thing, my
You
lord,
cannot have it both ways.
and second,
You cannot have it both ways because you cannot say that you will not give appointment to a person who is not a direct dependent because of NCWA. And cannot say that the direct dependent will not be considered because he is disabled.
no,
You
my
can't
lord,
have
my
it.
point is not that. Here is the point is not that, my lord. Your lordship's order is clear, my lord.
Yes, I have
It's
looked into
2016, my lord. Thereafter, my lord, he had not taken any step. He has come up with a circular. After the circular, my lord, that circular at the time of date was not in vogue. Now, after the 2012, he made an application. We considered it. We regretted it.
Yes, because the previous application was made long time back. It
Well,
was
that
made
has-
in 2000.
That has no role to play today, my lord. That has no role to play today, my lord. Now, so far his appointment is concerned, my lord, or application is concerned, it was regretted or rejected in 2006. Now, from 2006 till filing of the writ petition, my lord, he had done nothing. That was my bone of contention, my lord.
It was rejected in 2016.
Yes, my lord.
Not 6.
16, my lord.
16.
2016, my lord.
Yes.
Because he made the application in 2012. So 2016, it was rejected, my lord. Thereafter, he did nothing. So, my lord, as per the tenets of the compassionate appointment, my lord, so long lapse, it plays a vital role. And now, so far this act is concerned, my lord, there is a notification of the central government, my lord. May I hand it up to your lordship? It's a notification of 2022. Where it applies, my lord. First of all, my lord, number 4, persons with disabilities, my lord. Age relaxation of 10 years, 15 years for SC, ST and 13 years for OBC candidates in upper age limit shall be allowed to persons with disabilities suffering from blindness or low vision, deaf and hard of hearing, locomotor disability including cerebral palsy and all these, my lord, autism, intellectual disability, specific learning disability and mental illness and multiple disabilities from amongst persons under clauses A to D including deaf blindness in case of direct recruitment. Direct recruitment to all civil posts and services under the central government. My lord, two hinges are there, my lord. 2 hinges are there, my lord. One is it's a direct recruitment, and second, it speaks of civil posts or service under the central government. None of this fits me, my lord, because as your lordship knows, we are a company and we are a PSU, my lord. So we are not a government department. I may place the case laws
Now the main hurdle that he has to cross is what was he doing after 2016?
Now, may I place the case laws if your lordship wants?
First, let him cross that hurdle. What was he doing from 2016 till 2022?
No explanation.
My lord, the problem is that with the ACL in all the matters, my lord, the problem is that the latches is on the part of the petitioner, my lord. But I have applied when the notification was issued with regard to providing employment, my lord. Then and there, my lord, I have applied.
From 2016 till 2022, what were you
My lord,
doing?
what is the real scenario is that, my lord, we have been given assurances that you will get the job, don't worry. This is the assurances been given me. If you lordship remember in the earlier matter, my lord, yesterday.
That was on a different set of facts. This case, it was already rejected in 2016. Now, what were you doing from there? Because there is no communication between 2016 and 2022.
My lord, I admit that from the documents, my lord, I cannot show, my lord, if there is any communication. But my lord, if your lordships kindly consider the condition.
How can I consider? There are principles on which compassionate appointment is to be granted to people. Because the courts have repeatedly held that because there are so many people who are waiting in the queue who are more eligible than you are, that you should not be preferred if you have not been uptight about, if you have not been vigilant about your rights. Now, what do you want the court to do? You tell me.
I am vigilant, my lord. We are applying in
You are
due time,
vigilant.
my lord, kindly consider this. We are applying in due time.
All
The
right.
conduct of the ECL is that they are delaying the matter, showing some central government notifications that they cannot be allowed after this time.
From
This is the problem.
2016 to 2022,
Your lordship
what have
kindly
you
consider
done?
the legitimate expectation, my lord. Kindly consider that part, my lord.
There is no legitimate
These
expectation
people, my
for
lord, if your
compassionate
lordship
appointment.
kindly sees, they are completely handicapped, my lord. He cannot earn the bread of the family, my lord. This is the position of the family, my lord. That is, and my lord, 100% handicapped, my lord, to hire a lawyer, my lord, that is also, my lord. I'm making this submission, respectful submission. Kindly consider their part, my lord.
In 2022, he could hire.
My lord, if your lordship, one thing, my lord, if your lordship kindly consider the writ petition, my lord, 14/10/2016, page 28, my lord. The case is preferred after a lapse of 14 years. It should be disposed of with MMCC. That has also not been given. And my lord, according several judgments are there of the Supreme Court and the High Court where it has been stated that if no appointment is being given, at least pay the MMCC to survive the family. That has also not been done.
MMCC for female dependents. Who is he?
My lord, my mother recommended me for employment, my lord.
MMCC for female dependents under clause 9.5.
My lord,
This person is not a female dependent.
no, my lord, my lord, since my mother was not eligible, he recommended my name for employment on compassionate ground, my lord. My mother is alive, still alive, my lord. He's not.
So is the writ petition filed by your mother?
No, my lord.
Then how will I give you?
Then
Take appropriate steps so that the court can give you.
I will amend the cost title, my lord. My lord.
How?
No, I will.
Your entire cause of action is on compassionate appointment. What are you saying? Your prayer is the entire.
My lord, kindly consider prayer B, page 14, my lord. My lord, due to the nature of mandamus,
Yes.
appointment on compassionate ground under the direct
Yes.
category in favor of the petitioner immediately without any further delay, since no monthly cash
Yes.
compensation has been paid to either of the petitioner or his family members
Yes.
till date.
Yes. So what is the prayer?
Since, my lord, the MMCC has not been disbursed,
Ashun,
lordship kindly consider that part, my lord.
the petitioner prayed for compassionate appointment in place and stead of his father. Full stop. The petitioner's father was an employee of Eastern Coalfields Limited, within bracket ECL, bracket closed, who died in harness on February 23, 2000. Full stop. Initially, a prayer for appointment of the petitioner's brother-in-law, a prayer for compassionate appointment for the petitioner's brother-in-law was made by the petitioner's mother by a representation dated May 17, 2000. Full stop. The prayer for compassionate appointment of the petitioner's brother-in-law was rejected on August 19, 2009, since the petitioner, being a direct dependent of the deceased employee, was present. Full stop. Next. After the said rejection, no steps were taken till 2012. Full stop. Thereafter, an application was made in 2012 for employment of the petitioner in disabled category. Such prayer of the petitioner was rejected in 2016 by the ECL. Full stop. Next. Mr. Da, learned counsel appearing on behalf of the petitioner submits that the petitioner, being a disabled person, could not take necessary steps to take steps in accordance with law, challenging the said rejection. Full stop. Next. Mr. Das, learned counsel appearing on behalf of ECL, submits that there is no communication since 2016 till 2022. Full stop. The said lack of communication for almost 5 years goes to show that the bereaved family was not in need of immediate financial assistance. Full stop. Therefore, the petitioner's prayer for compassionate appointment cannot be considered due to delay and laches on the part of the petitioner. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that the petitioner has not been vigilant about his rights. Full stop. After the initial rejection of compassionate appointment of his brother-in-law in 2009, the petitioner did not take any steps. Full stop. In 2012, the petitioner made an application for compassionate appointment. Full stop. Even after the rejection of such application in 2016, the petitioner did not challenge the same till April 19, 2022. Full stop. Next. The reason for granting of compassionate appointment is to provide immediate succor to a bereaved family who might face immediate financial hardship due to the sudden death of the breadwinner of the family. Full stop. A prayer for compassionate appointment cannot be considered at a much belated stage. Full stop. Next. A beneficial reference may be made to bole blank রাখুন আমি ওটা দিয়ে দেবো ওটা লিখুন স্টেট অফ ওয়েস্ট বেঙ্গল ভার্সেস দেবব্রত তিওয়ারি next in the light of the discussions above WPA 22102 of 2022 bolded is dismissed bolded. Server copy, certified copy.
My lord, only one indulgence, my lord. This order will not debar me from exercising my rights with regard to MMCC, my lord. That may be.
You have no right. You are not a female dependent. You please look at the provisions of NCWA before making such submissions.
Item number 57 and